So again, thank you so much, Mr. Green and all panelists for their remarkable thoughts on the impact of the COVID to several aspects of the life. And also thank you for the Journalists and Writers Foundation for organizing this event today. So as experience, the spread and subsequently the impact of the virus is beyond walls. However, in my session, I will take your attention to the situation within the walls, with a specific focus on the reactions of Turkish authorities to the pandemic in prisons. After the announcement of COVID-19 as a global pandemic, the Council of Europe's Committee for the Prevention of Torture, CPT, immediately produced a set of principles for member states to follow in their approach to people who are deprived from their liberty. As one of the signatory countries of the Council's European Convention of Human Rights, Turkey is one of the addressees of these principles. When we analyze the key recommendations within the principles, member states are required to improve the conditions of prisons to the level of international health and safety standards. They are also required to ensure that prisoners have the access to medical care, medical equipment, medical staff at any time. Further, they are required to ensure that any restrictive measure can only be taken if it's necessary and proportionate. Also, they are required to ensure that absolute nature of Article 3 CHR, which is a prohibition of torture and ill treatment, shouldn't be violated. So there is no derogation, limitation, or excuse acceptable if a taken measure lead to infringement of this prohibition. Last but not least, member states, they are required to use alternative means of deprivation, such as early release, probation, house arrest, if applicable. So the rationale behind this principle is very clear. Any inadequate level of health or safety measures can rapidly lead to situations.
Mr. Haylamaz, forgive me for interrupting. You're doing a brilliant job here, but there are some papers that are, I think, on top of your microphone, and they are making a horrible noise that's drowning you out. So could you please move those papers away from your machine or your microphone? And please continue, sir.
No worries. So after analyzing these principles, it is clear that these principles have one target, which is any inadequate level of healthcare and safety measures can rapidly lead to situations falling within the scope of Article 3 prohibition, namely inhuman and degrading treatment. So the question arises whether the Turkish criminal legal system and also Turkish authorities have achieved to implement these principles enshrined under ECHR as a response to combat with the global pandemic. In early spring, we start to hear COVID cases in prisons throughout the relatives of the detainees who expressed the severe situation in Twitter. However, the first official statement about the spread of the pandemic in prison was made on April 14th, and accordingly, there were 17 confirmed cases and 3 deaths at the time. Another statement came on May 22nd, where it was reported that a total of 82 confirmed cases only in Silivri prison, which is just one prison, and one prisoner had died. However, both opposition parties and also human rights organizations have raised an issue that government has not been transparent about the number of COVID cases in and outside the prison. The People's Democratic Party, for instance, produced a report by also gathering the data from the families and lawyers of prisoners. And in this report, it illustrates that number of cases and death rates in prison is much higher than the official statements, and health and safety measures have not been taken properly. For instance, the report underlines several problems. Wards and corridors, they are not cleaned regularly. Masks, gloves are not regularly distributed in prison. Most of the prisons are suffering from the overcrowded population that also accelerates the spread of the virus. The food service in canteens, for instance, they were stopped, and the quality of food sharply declined, which directly weakened the immune system of prisoners, hence increased their chance of being affected by the virus. Also, when prisoners, they file a complaint in regard to COVID, Instead of enabling medical staff access, authorities automatically gave them a medicine called paliquinil, which is actually a medication used to combat with malaria. So temporary solutions are taken. Also, the state website enables to check recent medical situation of the prisoners. However, inmates' relatives and lawyers report that the medicine is providing a misleading information that it reveals that inmates are taking medical support. However, when they are speaking with the inmates, they understand that these are just temperature checked by prison guardians. So, without a doubt, the report illustrates that the fact that Turkey has been practicing a potential violation under Article 3 ECHR by failing to comply with its positive obligation to prevent inhumane and degrading treatment. On the other hand, on April 14, 2020, the government enacted a highly contested amnesty law that enabled the release of around 900 prisoners. It is contested because of several reasons. So first, it categorically excludes all political prisoners facing terrorism-related charges from its scope, which has been the terrorism-related charge that we know is like it's always interpreted broadly by the authorities. Secondly, it only applies to those whose sentence were finalized. Hence, release doesn't include whose trial proceedings at pending. So the amnesty law has been strongly criticized because of its unfair and discriminatory nature, which contradict with Article 2 as well as Article 14 of ECHR. This categorical blanket exclusion prevents the release of an additional 50,000 prisoners, including journalists, human rights defenders, lawyers, activists, and all other political prisoners arrested or convicted with terrorism-related charges. Can Dündar, which is a journalist in an exile, described this unfairness of the bill in Washington Post by stating that a bureaucrat who accepted the bribes could be released, while the journalist who reports on the bribery would remain imprisoned. On the other hand, the bill is problematic under Article 6 of ECHR, which is a fair trial provision, because detainees whose case at pending cannot benefit from the amnesty law, and they cannot finalize their proceeding due to either the closure or limited operation of the judiciary. From February to mid-June, Turkish courts had been suspended due to the pandemic and no trials were held. Although the courts have started to operate after mid-June, it is restricted due to the health and safety reasons. So there are limited amount of trials for thousands of delayed proceedings. As a result of this backlog in judiciary, detainees cannot benefit from amnesty law and continuously being deprived from their liberty. In other words, detention, which is supposed to be a legal precaution, has turned into a punishment at the moment in Turkey. So, in a nutshell, when we analyze the reactions of Turkish government to cope with the impact of COVID-19 with a specific focus on prisons, we can detect a couple of potential ECHR infringements. So first, under Article 3 ECHR, Turkish authorities may be found failing to take necessary measures to ensure the right to health of prisoners. Secondly, the enacted amnesty law immensely contradict with Article 2 in conjunction with Article 14 due to its discriminatory nature as a result of the blanket exclusion of political prisoners. Finally, the enacted amnesty law and the backlog in court proceeding deprive detainees' right to fair trial, which is protected under Article 6 of the ECHR. So thank you so much for listening to me, and again thank you for the Journalist and Writer Foundation to organize this event and promote the human rights advocacy throughout the world. I wish all participants and audience safe and healthy days. Thank you.